afternoon. Supreme Court, Natasha speaking.
Hi, Natasha. Could I speak with the self-represented litigant?
Speaking.
Okay. Natasha, my name is Suresh. I'm calling in relation to an application that...
Yes, I'm aware of the email that was sent out to you this afternoon.
Okay, fantastic. So, just wanted to clarify a few things about this.
No worries.
First of all, I'm just bringing up the court rules. Do you know specifics? I'm not sure what the prothonotary means when they say that the decisions are undated, because I think the information about when the decisions were made is provided in the originating motion. Do you have it in front of you, the originating motion?
No, I don't. Was it filed on Redcrest, was it not?
Yes.
Okay, let me go to your e-filing ID and let me have a look. Okay. Okay, I have the originating motion. So what was your question, sorry?
So I'm told that the application was rejected because the prothonotary feels that, just bear with me, let me bring up their email a second. So they've used Rule 28A.04, the 2A part of it, which do you have access to that rule?
Yeah, I'm aware of that rule, yes. What do you need to know about it? So this gives the powers of the prothonotary to have a look at a proceeding and decide whether it should be sealed or not sealed. Would it be irregular or an abusive process of the court if it were to be sealed?
Yes, but if it complies with the rules, then whether or not it's an abusive process should necessarily be a judicial determination.
No, it's not. There's a rule that allows, as he has advised you under Rule 2804, powers of the prothonotary to make that determination. So 2804, subsection 2.
Okay, I can see that rule. I just think that it's unconstitutional because it calls for an evaluation of the allegations that are being made or of the application that is being submitted. But moving past that, I understand that's not something you can help me with. I'm trying to understand the specific objection that they're raising with the originating motion that has been lodged. So I'm bringing up the originating motion as we speak.
Mm-hmm.
Okay, so I have it in front of me now.
Okay.
It's loading up. Okay, so the orders that are sought Okay, so if he or she is implying that the details of each of the orders is not provided, then isn't that something that gets isn't that information that gets furnished through the documents that are filed in support, like the affidavit in support or the statement of claim that may be filed in support?
Yep, so I'm having a read of your originating motion.
I mean, this is not the only document that will be filed in the proceedings. If there
Yeah, look, that's right. Look, if you file an affidavit in support, that would have all the information and all the decisions in which you are determining, but that would be, so the information provided at the moment is insufficient. You can retry to file this with all the dates of all the decisions and file an affidavit in support with all the decisions on it. It's noted that one of the rejections that it was mentioned that largely undated decisions, if they are a decision that has been made, why weren't the dates entered into the originating motion?
So you can look at the originating motion as we speak, and you
Yep.
see that it's already 20 pages.
Yes.
Because it is, the substance of it is rather elaborate. The matters that are covered are quite extensive, and if we were to go into more detail, it wouldn't be an originating motion anymore. It would be, I mean, those details go into the affidavit in support.
Okay. Well, at this stage, based on the information that you provided, it was, as I said, it was rejected under 28 by the decision by the Prothonotary, and your only course of action now is to request to send that before a judge, and it'll be the decision of the judge whether it should be sealed if the Prothonotary's decision was wrong.
Okay. So I did try filing an affidavit. Well, so yesterday, when we were trying to bring in an urgent application in support, pursuant to this lodgement, we had filed an affidavit in support in this particular proceeding. I understand that wouldn't have gotten to the Prothonotary because it wasn't filed through request. So, before this is sent off to a judge, I'm trying to see if we can find, if I can understand what specific issues that the Prothonotary has which may be cured without...
Well, it can't be at this stage. So once a decision by the Prothonotary is made not to allow a document for filing, they have looked at what you've currently filed, and by fixing like little issues, cannot overturn the decision of the Prothonotary. Now, the only course of action is to have that decision reviewed by a judge of the court. The only way you'd be able to do it is you were to scrap this one and start again with an originating motion, ensuring that you comply with any of the decisions that were made while it was
rejected. I'd like to go to a judge. How do I do that?
Okay, you can just reply to that email saying you request it to be reviewed by a judge, and we will organise that as soon as possible.
But I wanted to bring in an application for urgent injunctive relief in this proceeding, today. So if this first needs to go to a judge, then it'll have to be through an urgent application process.
These are not normally dealt with in an urgent nature, but we will raise it before the practice court and see what they have to say. So if you can reply to the email stating what you would like done, basically stating and also why it's urgent, then just put it all in writing about why it's urgent and why you require some sort of application heard today or whenever you require an urgent. What's your urgent meeting?
So we want the appointment of the manager to the firm to be set aside. Now, we have a number of urgent hearings that are coming up, including early next week. The manager has seized all the case files. He has seized access to all the resources. He has instructed all the solicitors that were acting in the matters to stop acting. So,
okay.
Essentially, we won't be able to prepare for the proceedings that are coming up next week.
Okay. Put that all in writing, basically, about what will happen if you don't get a hearing today. I'll let the practice court coordinator know that you're seeking an urgent application, and then we'll go from there and work out how we proceed from there, okay?
Okay, but can I also submit the affidavit in support that I wanted to submit with this application?
You can't submit on Redcrest because there's no active proceeding, but when you reply back with this email, attach the affidavit there and we'll consider it on both grounds, okay?
Sorry, on both grounds? What do you mean? What's the section?
Like in the sense of that we'll consider your urgent application and by having your affidavit in support, and we'll then seek the grounds of having it for the urgent application, also for an urgent application for having the Prothonotary decision overturned.
Okay, and may I also note that the first round that the application had been rejected in pursuit of was that the lawyer that was representing the parties does not have a valid practicing certificate. Now that was false. The Prothonotary has accepted implicitly by backing off of that allegation.
I've seen that. Well, he has said he knows that, what was the exact wording, sorry, I'll just make sure. Note your assertion that the assertions that you've said that he's got one. We're not saying that we agree with that at this stage because it's not for us to make that decision.
Yeah, but
we're saying that we agree that we know that you've made that assertion that Mr. Ansell does hold one.
Okay. Do you work for the Prothonotary?
I work in the Prothonotary office.
No, when you say we, I want to know if you're independent of that office or am I dealing with part of that office?
Well, the Prothonotary, he looked at your documents. I work as the self-represented litigants coordinator of the office,
Is your office
which we're all in the same building.
No, I'm talking about the executive powers that are applicable here. Do you, in the chain of command, are you under the Prothonotary?
I am. I'm the Deputy Prothonotary.
Okay, well then this is not a very independent process.
It's not up to me to make any decisions whatsoever. As I said,
no, I'm not
it's now to be referred to a judge.
Okay, so I think that whether or not the person representing me or representing my companies holds a current practicing certificate is not something that the Prothonotary will check for each application. So necessarily,
correct. That's why we've said we're not going further with that.
The fact that it was raised in the first place is a breach of my rights under the Charter of Human Rights and Obligations because I'm being treated differently by the court. I am not being treated like everybody else would be, as is guaranteed by the Charter of Human Rights and Obligations. It's also under the International Covenant on Civil and Political Rights, which is a schedule to the Australian Human Rights Commission Act. I am being treated differently by the court. And that will be part of the...
I was just going to say, that can be part of your grounds about why your application should be considered.
That's right, yes.
So if you put it all in writing to me, reply back to the email that was sent, and we'll organise... I'll have conversations with the practice court coordinator, letting them know it's coming, and as soon as we get your email, we'll then be able to assess it.
Okay, and what's your name?
Natasha.
Natasha, how do I email you?
Just reply back to the email that was sent to you earlier.
Okay, and what's the name of the Prothonotary?
Mr. Rod Ratcliffe.
Okay, and they're not an associate judge or a judicial registrar?
No, they are not.
Okay, thank you. Cheers.
No worries at all. Bye.